Hi, thanks so much for joining us for our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Ben Grau, a Louisiana construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous Ben Grau.
Thank you, Jesse. Appreciate it. As Jesse said, we're here to talk about how to get you paid quickly and how to leverage liens, bonds, and contracts in Louisiana to do that. If you've ever been forced to chase down a payment, you know that being owed money and actually receiving that money and collecting it are two very different things. And today I'm going to talk to you a bit about that and give you some strategies that I think will help you get paid more quickly, as that is ultimately your goal. Before I dive into that, as Jesse said, my name is Ben Grau. I'm a partner here at Simone, Perigine, Smith & Redfern in New Orleans. I have 25 years in practicing law in Louisiana, Texas, and in various venues across the state, including in arbitration matters. Primarily handle commercial litigation, including construction law, insurance law, and business disputes. And so as I said, my goal here today is to share some practical strategies to help you secure timely payment on your construction projects. So why does that matter? As you know, delays in payment are one of the biggest financial threats in the construction industry. The margins are very tight in your business, and getting paid is a key to staying viable in that industry. Knowing how to properly document your rights and enforce them makes you a serious and credible player in the marketplace. Owners and contractors are far more likely to pay you quickly when they know that you followed the rules, that you're prepared, and that you are willing to go to bat to enforce your rights. What are we going to cover today? We're going to first talk about using liens for quick payment, then we'll talk about leveraging your bond rights. And finally, we'll talk about strengthening your contract terms. Lastly, we'll talk about using demand letters to pressure payment, and then we'll take any questions that you might have. So first, let's talk about using liens for quick payment. I'm sure you know what a lien is, but just to refresh, a lien is a legal claim against property for unpaid work or materials. It creates a cloud on the property's title, making it impossible for the owner to refinance or sell until that lien is resolved. Who can file a lien in Louisiana? A general contractor can file a lien, subcontractors can file a lien, material suppliers, equipment leasers, and laborers can do so. What are the steps to file and use a lien as leverage? And that's key, the leverage part, because you don't necessarily want to go through a drawn out legal fight over your lien, but you want to use that lien to get yourself paid quickly. The first thing that you should do is you should send a preliminary notice. Now, under Louisiana law, you don't always have to send a preliminary notice in order to have the right to file a lien. If you're a general contractor doing work for over $100,000, you have to file that preliminary notice. If you're a lessor or seller of equipment, then you also may need to file a preliminary notice. But it's my recommendation that regardless of whether you need to send a preliminary notice, you should do so in every case. It alerts the owner to your presence on their job site. It also puts the owner on notice that you're a contractor or a party that understands their lien rights and will take the steps necessary to get themselves paid. The second thing you want to make sure you do is you want to file your lien within the applicable deadlines. The deadlines are different depending on your role on the project as a contractor, subcontractor, material supplier, or lessor. And so you want to make sure that you know what those deadlines are in your particular case. In general, if there is no notice of termination filed on a project, then a subcontractor or supplier has 30 days to file a lien. And a general contractor has 60 days to file a lien. If there is a notice of termination filed on a project, then everyone has 60 days after substantial completion to file that lien. Again, let me just make sure I said that clearly. If there is a notice of termination filed, then a subcontractor and supplier have 30 days and a general contractor has 60 days. If there's no notice of termination filed, then everyone has 60 days from substantial completion. The third step is you should send a demand letter before filing your lien. Again, it's not required to do this, but as we'll talk about later on, the demand letter is a key part of the process to leverage your rights to get yourself paid quickly. And then finally, if you're ignored in your demand letter and then you want to file that lien, you want to notify the owner of it, and you want to enforce the lien if you still don't get resolution. And you have 1 year to file suit on a lien in order to enforce it. If you fail to file a lawsuit within 1 year of filing your lien, then the lien can be extinguished and your lawsuit, while you can still go forward on your claims for payment, you lose that right or that cloud over the title. Why liens get you paid quickly? Owners hate liens. They delay the financing and sale of their project. It puts pressure on the general contractor to resolve the disputes quickly. And finally, you want to leverage that lien enforcement for faster results. Let's talk about leveraging your bond rights. Bond rights are similar to a lien, but slightly different. On a public project, liens are not an option. You can't lien the city hall or the government building. Instead, the contractor has to provide a payment bond to ensure that subcontractors and suppliers get paid. So when can you file a bond claim? In Louisiana, a bond is required on all public projects over $50,000. Many private projects also have voluntary payment bonds secured by the general contractor. You want to use those bond claims, making a claim against the surety, to leverage payment. So what are the steps to filing and enforcing a bond claim? The first step is you want to send a notice of non-payment. Under Louisiana law, a subcontractor and supplier must send written notice to the contractor and surety within 45 days after the project's acceptance. In your notice, you want to mention the failure to pay, and that failure will lead to a bond claim if not resolved. You then want to use the surety as leverage against the general contractor. Sureties can deny the general contractor future bonding, which will prevent them from getting future public projects and private projects. And the surety will let the contractor know that an unpaid bond claim will impact their ability to perform future work. Why does this get you paid more quickly? One, a surety company has the money. So if the reason you're not being paid is because the contractor is insolvent or is in a cash flow problem, that problem doesn't exist for a surety company, which is a large insurance company. Secondly, the contractor does not want bond claims on their record, so they'll prioritize getting you paid over other people. Finally, bond claims are very expensive for contractors. They have to indemnify the surety company for all the costs that the surety company incurs in dealing with your bond claim. And so they will, contractors will work quickly to ensure that the surety doesn't incur excess costs that they're also going to be responsible for. Again, the tips for effective use of a bond claim: you want to act quickly, you want to follow the terms of the bond, you want to provide documentation to the bonding company, and you want to escalate that when necessary. If you haven't gotten a response, you want to follow up again, and you want to make it clear that you're ready to file your formal claim. Let's now talk about strengthening contracts to prevent delays. What do you want to make sure you're included in your contract? You want to have clear payment deadlines with penalties. You want to specify when invoices must be paid, and you want to specify the penalties for late payment of those invoices. Second, you want to try to limit retainage to avoid excess withholdings. Get it down to 10% at the most, but try and get it down to 5%. Also, try and include provisions for when that retainage has to be released, particularly if you're an early contractor or subcontractor on a project. Finally, you want to make sure that there are clear dispute resolution clauses in your contract. You want to require mediation, and you want to consider requiring arbitration to prevent drawn-out court battles. You may be familiar with the American Arbitration Association, and they have provisions for what's called fast-track arbitrations. When the amount of money is relatively low, $50,000 or less, or you can set other limits like $250,000 or less, you can proceed to a fast-track arbitration that will keep your costs down and get you paid more quickly. You do want to be aware of pay if paid clauses. Louisiana now allows sureties to use this as a defense. They used to not do that. And so you want to try and limit pay if paid clauses if you can, or put provisions into the pay if paid clause that will require the contractor to pay you if they are engaged in a drawn out legal battle with the owner. Now let's talk about using demand letters to secure faster payment. Demand letters are a very powerful tool when used correctly to ensure that you get yourself paid. For it to be an effective tool, you want to ensure that your letter is professional, effective, maintains your business relationships, and focuses on the key issues that are preventing you from getting paid. What do you want to include in your letter? Well, the first thing you want to do is you want to clearly identify yourself, identify your claim, and you want to send that letter identifying you before you engage in the lien or bond process. Secondly, you want to reference Louisiana law and any deadlines. Third, you want to make sure that you provide support for the claimed amount. You want it to be as detailed as possible. Attach the invoices, break down the amounts to make it clear that there is support for the amount that you're seeking. Finally, you want to make sure that you give a firm deadline for payment. Lastly, you want to write a clear, well-written letter. It's very important that you sound like you know what you're doing in your demand letter. You want to keep it professional. People oftentimes say they don't want to send a demand letter because of the business relationships they have with other contractors. But if you write a well-written, clear, professional letter that is not overly aggressive or overly antagonistic, you will not ruin your relationships. Rather, you will strengthen those relationships because the owners and contractors will treat you as someone that knows what they're doing, understands their rights, and simply wants to get paid to avoid protracted litigation. How do you write an effective letter? First, you want to avoid emotional language. You want to be clear, concise, and professional. You want to state the purpose of the letter up front in a polite but direct way. You want to outline the facts and attach the supporting documentation, as I mentioned. You want to show that you know the law, the contract, and your rights. You want to close on a positive, solution-oriented note. And when necessary, you want to consult a lawyer to make sure that you're saying the right things in your letter. A couple of last tips. We would recommend that you send that letter via certified mail or an email with a read receipt so that you've got confirmation that it's been received. You want to make sure you save a copy of that letter that you send for your own records. And you want to follow up with a polite phone call or email if there's no response to your letter by the deadline. Sometimes these things get lost, sometimes they're in the process, and just because the deadline is missed, you don't want to have to run off and file your legal pleadings or incur additional costs. Try a phone call first. With these tips, we believe that you will be successful in leveraging your lien rights, bond rights, and your contract language to getting yourself paid more quickly. No one wants to be in a drawn-out legal battle, and that's oftentimes what will happen if you don't use these tools effectively as leverage to get yourself paid. And the demand letter is the best way to have that happen. So again, how do you get yourself paid quickly? Use the liens, bonds, and contracts to your advantage. Document every step of the way to show that you're a credible party who knows their rights, and then move to enforce your rights quickly if you're not getting the results that you need. At this point, I will happy to answer any questions you may have regarding how to leverage these tools to your advantage.
Well, first of all, thank you so much, Ben. You really are wonderful in breaking it down for us. We do appreciate it. There are a couple of questions that came through.
Sure.
The first one says, who files the notice of substantial completion? How do I know if it was filed? Is it in the public records?
Yes, it is in the public record, and you can search the mortgage or conveyance records for that. You can also ask the general contractor for a copy of the notice of substantial completion. It is signed by both the owner and the general contractor, and usually the architect as well. And it's usually filed by the general contractor, but sometimes the owner will file it into the record as well.
Okay, perfect. And then I think you already covered this, but we're going to ask it anyhow. How long do I have to file the lien after the notice of substantial completion?
So if there's a notice
is filed, and this goes for a GC and a supplier and a sub.
Sure. Let me just go over
like,
those.
Is there any difference between a GC and a sub? Yep.
Sure.
Of course.
And to be clear, the triggering event on these deadlines is what's called a notice of termination, which is different than a notice of substantial completion. Substantial completion says that the project is substantially completed. Notice of termination says that the contract between the owner and the general contractor has been terminated because it's been satisfied or fulfilled in its entirety. If there's a notice of termination that's filed, subcontractors and suppliers have 30 days to file their lien. General contractors have 60 days to file their lien. If there is no notice of termination that's filed, then everyone has 60 days after substantial completion of the project to file. And substantial completion will be the date in the substantial completion certificate that's filed, or alternatively, it will simply be the date when the project is in fact substantially complete if there's not a certificate that's filed to that effect. I hope that answers the question.
I think so. I think it does. I have my own follow-up question.
Sure.
Do any of those deadlines differ if the notice of contract was not sent by the GC?
So if there's no notice of contract that's filed, a couple of things to remember. One, the general contractor has no lien rights at all. Used to be a little bit of a disagreement in Louisiana about that, but the Supreme Court has clarified and the legislature has clarified that if you don't file your notice of contract, then there is no lien rights whatsoever. If there's no notice of contract that's filed, the deadlines do differ for subcontractors and suppliers, depending on the particular situation that you're in and depending on the amount of the contract. And so you do want to look at those deadlines and a little bit more closely to make sure that you're filing your lien timely in the event that there's no notice of contract that's on file.
All right, perfect. I do think that those are the only questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Can you go to the next slide for me, please, Ben?
Sure thing.
All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's so many things available for you, so please check it out. I encourage you to do so. All right, and then the next slide. All right, our next webinar with Ben is going to be what happens, this is actually going to be with Denise, one of Ben's colleagues. This is what happens after I record my lien and how do I get paid. That's going to be March 19th at 2 p.m. So go ahead and register for free at sunraynotice.com/education. And then the next slide for me. Perfect. If you don't mind, give us a moment, give us a review on Google. We really appreciate it. It only takes about a minute of your time, but it helps with other contractors to hear about us, get information. And it also, we really do appreciate the feedback and it helps us better our webinars and the content we're sharing with you. So I hopefully you can go ahead and take care of that for us. And then if you would, the last slide for me, please. Thank you so much. And with that, that is all we have for you guys today. Thank you so much to everyone that attended. We hope to see you at our next webinar. Again, thank you so much, Ben. You really are wonderful. I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone.